I think the arbitration rules are important to the parties because they do several things that wouldn't otherwise be available to the parties. The first thing they do is they create an opportunity to appoint the tribunal at an early date in a predictable process. The second thing they do is they allow for interim relief to be awarded by an interim arbitrator in case you need it immediately. And the third thing is, in the past, on ad hoc arbitrations, parties have generally spent a lot of time negotiating the procedural agreement before the arbitration starts. In this case, it's done for them. We updated the rules because we felt that the practice of arbitration in the last 10 years had made a significant evolution. The rules were designed originally along a court-based model. We're now finding that the practice of arbitration, the best practices, are really designed for a more international arbitration format. So we wanted to adopt some of the best features of international arbitrations into the rules. We also wanted to update the rules to reflect all of the changes in legislation and the best domestic practices in Canada, which we did. So those were the primary drivers behind changing the rules. We also thought we could improve the format and some of the readability and accessibility for those rules. So that was what was driving us. ADRIC has a standing rules committee. It's been in existence for a long period of time. Membership changes from time to time. I had the privilege of chairing it until 2013 when Angus Gunn took over. The consultation process we went through is that we actually went to every region of ADRIC and asked them to contribute to the changes to the rules. We went to the leading practitioners in Canada and we asked them to contribute. We also went to the major arbitration organizations in Canada and asked them for input. Out of that, we got an enormous amount of material. A lot of it disagreed with the general practice, and a lot of it created disagreement on the committee. We had lengthy debates about those disagreements, and we resulted in what I think is a really excellent set of rules. We also did a survey of people where we asked them specifically about specific rules and got input that way. Those were incorporated into the discussion by the committee. Finally, when we had a set of rules we liked, we went to a wordsmith and we had the rules put into what we felt was a plainer form of English. There were some problems with that because some of the plain English isn't legal English. And we resolved those over a period of time by a lot of wordsmithing on our own. I think the most notable changes in the rules as they now stand is the prohibition of examination for discovery except as may be ordered by the tribunal. It will force the parties to think about what examination they actually need. The second aspect is the production of documents. Production of documents happens early in an arbitration and can be followed up by requests for documents. Thirdly, we've introduced a specific provision for confidentiality and privacy. And that provision, surprising I think to most people, it is something that is not included in the statutes and not included in general practice except as required by the parties. The other major change was the power to appoint an interim arbitrator pending the appointment of the tribunal and to provide for interim relief, and we've greatly expanded the scope of the interim relief that can be provided. There are a number of smaller changes that I think will make the rules easier to use. We now have electronic versions. We've put it in pamphlet form as well, which you can obtain free from the ADR Institute of Canada. We've changed the rules to allow specifically for deposits and how they're handled by the ADR Institute of Canada. We've provided for things like security for costs and a broader range of interim relief, which will be beneficial to parties during the course of the arbitration. Anyone can use these rules. They're well suited to commercial practice. They can be used in international arbitrations. They can be used in just about any sort of dispute between parties in Canada, and they are really, really set up to do the best possible job of an efficient arbitration of virtually any dispute. They're not well suited to family law disputes, and family law has developed its own format for arbitration. They are, in my view, rules that should be incorporated in virtually every commercial contract in Canada. The model clause in the ADRIC rules is a clause which allows you to simply insert the clause in the contract, and you have all the benefit of knowing that the clause is consistent with Canadian law, and secondly, provides for a predictable and efficient process through the ADRIC rules. We see in our practice a lot of dysfunctional clauses which create difficulties for the parties. This is the one way that you can completely avoid those difficulties with some assurance that you're going to get exactly what you're putting into the contract. These are the best Canadian rules, and they're the best Canadian rules because they handle a wide variety of arbitration situations that could arise. They're also completely consistent with all the provincial legislation across Canada, including Quebec, and that is, in my view, a unique set of rules for Canada. They can also be used for international arbitration, and they are effective across Canada and effective in a legal sense of not creating legal problems of being inconsistent with provincial legislation. The rules apply to international arbitrations. They are not administered rules in the sense that we often see in international arbitration situations. But the ADR Institute of Canada will provide administration on request. So easily adaptable to that purpose, and certainly a reference in them to the UNCITRAL rules, which are well known by everyone in the international arbitration community. The parties can amend the rules because the rules are set up in such a way to be flexible for the hearing, which can be adapted to what the parties' needs are. That's a specific provision in Rule 1. It's often used. Most parties want to make some amendment to the rules in order to tailor the process directly to their dispute. The arbitration admin service offered by ADRIC is comprehensive. It covers the cradle-to-grave operation of an arbitration. It provides also for a degree of impartiality in the deposits and collection of fees, which arbitrators find quite comfortable because it takes that burden away from them. It also enables the parties to be educated about the arbitration process. So if you have any questions about how an arbitration can be administered, you can raise those questions with the staff of the ADR Institute of Canada. The services are available in both French and English, and they are comprehensive, or they can be as light as you want them to be depending on the circumstances of your case. The next revision is scheduled for about 5 years from now. There has been a continuing evolution in arbitration practice in Canada as the arbitration practice moves further away from the court model and more to the international arbitration model. You can comment by sending comments directly to the executive director at ADRIC. You can comment on the website, or you can comment to any of the members of the committee, including myself. I can assure you, based on our experience, that every comment is dealt with thoroughly by the entire committee. You can get the new ADR rules at the ADRIC website, adric.ca, and you can download it there. The rules cost nothing. They're absolutely and completely free. We expect that we will be handing out a number of the pamphlets at the various conferences that we host every year, and you can get one simply by attending the conference and going to our booth. Looking forward to seeing you. There are huge benefits to ADRIC. First of all, it's a non-profit independent organization which has regions right across Canada. It will provide independent and impartial neutrals in both mediation and arbitration. If you're looking for a neutral, you can go on to the ADR Connect portion of the website. You can also phone the ADR office. There are a number of services that are provided that would support arbitration and mediation, including administration of arbitrations and selection of mediators and provision of precedents and other documents that are going to be helpful to you.